We've seen many cases in which a shareholder is suing on account of some alleged misdeed on the part of corporate insiders. So here let's take a look at some of the rules and policy issues that surround these kinds of suits that affect shareholder litigation. A shareholder suit can be either a direct suit or a derivative suit. In a direct suit, the shareholder sues in her own name, seeking a remedy for herself. Direct suits are often brought as class actions in which the named or lead plaintiff seeks to bring the suit on behalf of a class of similarly situated persons, so fellow shareholders. In a derivative suit, the shareholder is in effect suing the corporation to compel it to sue on its own behalf to recover for the corporation as a whole. The logic of a derivative suit is that it serves as a counterweight in those situations when the fox, if you will, is guarding the henhouse. When the persons who control the decision-making of the corporation, including the decision of whether or not to sue, are the very persons who are alleged to have harmed the corporation and are therefore very unlikely to sue themselves. The idea is the derivative suit gives shareholders the ability to take over the prosecution of those claims in those cases where insiders are unlikely to police themselves. Because derivative suits inherently involve a derogation of the discretion we normally accord to management, the law imposes certain restrictions on these suits. Most important is what we'll see is called the demand requirement. Under the traditional and Delaware approach to derivative suits, the plaintiff must first make a demand of the corporation, asking it to bring the suit on its own. Unless demand is excused, a court will not permit a derivative claim until the demand has been made. In other words, giving the corporation the chance to pursue the case itself. Further, unless demand is excused, if demand is made and refused, the decision to refuse is evaluated under the business judgment rule. So here we've found a derivative suit. We've asked ourselves whether demand is excused and determined that it is not. And so now the question of whether or not whatever decision the corporation makes to go forward with the case will be evaluated using the business judgment rule. Okay? This means, as a practical matter, a derivative suit won't go much farther if demand is not excused, because in most all likelihood, the decision of the board will be to not pursue the claim. And that decision will be accorded the presumption of the business judgment rule. And so unless we can establish that the decision makers were not independent or acted in bad faith, there'll be no grounds for attacking the decision not to pursue the claim. It's also important to note that if you, by chance, make demand, in other words, don't take the position that it's excused, but go to the board in the first instance, that will trigger an assumption that demand was not excused. So in other words, it's a concession on your part, and the court will not revisit that assumption. And again, any subsequent decision by the board will benefit from the business judgment rule. The question of whether demand will be excused is therefore critical, and it turns generally on an assessment of whether the court is comfortable leaving it to the board of directors to police themselves. In other words, the question the court asks is whether or not the situation presents one appropriate for derogating from the usual presumption that the board is the proper party for managing the affairs of the corporation, including the proper response to wrongdoing by corporate insiders. And as we saw in Grimes, this assessment turns on whether the plaintiff has pled with particularity facts that create a reasonable doubt that the directors are not entitled to the presumption of business judgment, of the business judgment rule. So we have to show either that there was a breach of the duty of loyalty or a showing of waste or complete disregard of duty by the board in the action that's being complained of. As the Grimes court put it, one ground for alleging with particularity that demand would be futile, another way for saying would be excused, is that a reasonable doubt exists that the board is capable of making an independent decision to assert the claim if demand were made. The basis for claiming excusal would normally be that, 1. A majority of the board has a material, financial, or familiar interest in the decision that's being complained about, so a duty of loyalty problem. A majority of the board is incapable of acting independently for some other reason, such as domination or control, again, a duty of loyalty concern. Or 3, the underlying transaction is not the product of a valid exercise of business judgment. And again, in those cases where we can overcome the business judgment rule, we have to show there is either a lack of good faith, right, or a lack of informed business judgment. In other words, it's become, they so clearly did not perform the dance, if you will, that we cannot give them the presumption of the business judgment rule. If the stockholder cannot plead such assertions after using the tools at hand, again, a limited discovery, right, the stockholder must make a pre-suit demand. So in other words, you have to go back into the situation we just described, which is make demand, and then, if possible, attack the decision whether or not to proceed with the demand, again, by overcoming the business judgment rule. Again, an avenue that's unlikely to succeed. If, however, demand is excused, and therefore we are not finding ourselves in the business judgment rule context, and we are finding a situation where a court will allow a shareholder to pursue the derivative claim on behalf of the corporation because we don't believe that the board of directors is in a position to do it themselves because of their lack of independence, or because they themselves are so implicated in the decision through bad faith or a failure to perform their duty that we can't trust them to make the decision. Is that the end of the analysis? If demand is excused, in other words, can a board overcome the doubts that trigger the determination of demand futility by use of what is called a special litigation committee? If a special litigation committee recommends termination of a derivative action, we see under the Zapata test that a Delaware court will agree to dismiss the case, but only if the corporation, in other words, special litigation committee, can carry the burden of establishing that the special litigation committee itself was independent and that its decision was both reasonable and exercised, made in good faith, right? So they have to be both independent and, quote, have done the dance, very similar to the business judgment rule type cases in the duty of care context. But then on top of that, even if the special litigation committee can carry that burden, the next question is, does the court agree with the decision to dismiss, exercising its own independent business judgment? As the court in Zapata put it, first, the court should inquire into the independence and good faith of the committee and the basis supporting its conclusions. Limited discovery may be ordered to facilitate such inquiries, and the corporation should have the burden of proving independence, good faith, and a reasonable investigation, rather than presuming independence, good faith, and reasonableness. If the court determines either that the committee is not independent or has not shown reasonable bases for its conclusions, or if the court is not satisfied for other reasons relating to the process, in other words, they finding that the committee has not done the dance, including but not limited to good faith of the committee, the court shall deny the corporation's motion. If, however, the court is satisfied, the court may proceed in its discretion to the next step. Now, what is that next step? The second step provides, we believe, the essential key in striking the balance between legitimate corporate claims as expressed in a derivative stockholder suit and a corporation's best interests as expressed by an independent investigating committee. The court should determine, applying its own independent business judgment, and that's the critical phrase, whether the motion should be granted. This means, of course, that instances could arise where a committee can establish its independence and sound bases for its good faith decisions and still have the corporation's motion denied. In other words, the Court of Chancery does have the power to overrule an even well-formed, i.e. independent, and well-advised and well-acting committee, i.e. one that does the dance, if it concludes on its own, for reasons of its own, that the derivative suit should proceed anyway. They explain this by saying the second step is intended to thwart instances where corporate actions meet the criteria of step 1, but the result does not appear to satisfy its spirit, or where corporate actions would simply prematurely terminate a stockholder grievance deserving of further consideration in the corporation's interests. Now, what exactly that means is difficult to say, but they conclude by saying the Court of Chancery, of course, must carefully consider and weigh how compelling the corporate interest in dismissal is when faced with a non-frivolous lawsuit. And they mention the ideas of public policy. Generally, to bring a derivative claim, the plaintiff must have been a shareholder at the time of the alleged wrongdoing and hold the stock continuously through the conclusion of the litigation. So, for example, if a shareholder is cashed out in a merger, she would lose her standing to sue derivatively. But that is why, in most cases, if you're complaining about a merger, your claim is couched as a direct claim, where that requirement does not apply. Because of restrictions like the demand requirement and continuous holding requirements, and the possibility of having a special litigation committee take over your suit even after you've shown that the board is not independent, shareholders often prefer to bring their claims as direct ones. Direct claims also give them the right to seek recoveries directly for the plaintiffs themselves rather than indirectly by reason of a recovery to the corporation, which is then shared by all stakeholders. But it is important to remember, in both cases, often the motivation for the litigation is the opportunity to receive attorney's fees, which are possible in both kinds of claims. But in addressing this question of what is a direct versus a derivative one, the court in Tooley put it this way: an action is derivative or direct is sometimes difficult, and that's putting it mildly, and has many legal consequences, some of which may have an expensive impact on the parties to the action. Most often, if you find the case is derivative, that will often mean it is much more difficult for a plaintiff to maintain control and to not face dismissal by a decision of the board and or the special litigation committee to drop the suit. That's why the decision, as the Tooley case put it, whether a suit is direct or indirect may be outcome determinative. Right? Therefore, as the court said, it is necessary that a standard to distinguish such actions be clear, simple, and consistently articulated and applied by our courts. That is certainly the goal, but it still remains often very difficult to determine whether a claim can be is either direct or indirect. Indeed, it is often the case that you can be both. Because the determination is so difficult, there's been an effort to try to clarify what the actual rules are. This is the test announced in Tooley. The issue must turn solely on the following questions: who suffered the alleged harm and who would receive the benefit of any recovery. Basically, the determination lies in whether the plaintiff suffered any harm directly or solely by reason of a common harm suffered by the entity as a whole and therefore felt by each of its individual owners. But often it is quite hard to make this distinction, and often the same set of facts can support both a derivative and a direct claim. So while the standard may seem fairly straightforward, in actuality and in its application, in many cases, it is far from straightforward. So let's recap. Here's how one can analyze whether a shareholder suit is likely to proceed, an often very important question, particularly from the point of view of a plaintiff's lawyer, but also from the point of view of his defendant, the shareholder, the corporation and its directors. The first question to ask is the suit direct or derivative? If given a choice, I wonder, why would any plaintiff's lawyer choose to bring a derivative action? It seems that class actions are probably much more straightforward and less susceptible to these kinds of hurdles like demand requirements and special litigation committees. Well, one reason might be that you have no choice. There are cases that are clearly derivative and not not capable of being couched as direct claims. But also I would suggest that if you remember the differences between the power to indemnify under Section 145 of the Delaware Corporation Law between direct and derivative cases. And you'll remember that it is much more difficult to grant indemnification in a derivative case. And so I wonder whether the ability to couch a claim as derivative isn't a way of raising the stakes, if you will, thereby making more likely settlement for a plaintiff's lawyer going after a group of directors. Perhaps that is also what's going on. But however you come out, let's assume that, however that comes out, let's assume that you decide the case is derivative, or at least you are forced to make that analysis. Then the next question is whether demand was excused. All right. Now, first you remember that as a plaintiff's lawyer, you would never make demand on your own, because once you've done that, you've acknowledged that you're in the world of the business judgment rule. You've acknowledged that the board is in fact independent and therefore capable of making its own decision of whether or not to pursue the litigation, and that that decision will benefit from the presumption of the business judgment rule. So any rational plaintiff's lawyer would proceed as if demand were excused, and then the question will be whether it was. And so you have to look to the cases to determine whether what the standard is for excuse. And the first prong is whether or not a majority of the board has some financial or other interest, i.e. some sort of conflict, some sort of duty of loyalty problem as it relates to the matter that's being complained of. If that's true, demand may be excused. Or whether you are accusing the board of bad faith or of lack of an informed judgment, and thus challenging a decision that would not benefit from the business judgment rule, and therefore not from the benefits of exoneration. If that's the case, you may also have a demand excused case, because the very board that would make the decision of whether or not to pursue the case is the very board you are suing, and they all are facing exposure. But even then, if you're in a demand excused case, you must then ponder the next level of analysis and whether or not they have a valid special litigation committee. That would be a group of independent directors, usually directors who are brought on board after the events being complained of and therefore are clearly disassociated, unaffected by the claims. They are, quote, independent, and that's a very important first determination. As we saw in the Oracle case, independence can arise, a lack of independence can arise even if you are not a named defendant in the litigation, if your relationships with those who are named are sufficiently strong as to impugn your independence. All right? But assuming you have an independent group, then the question is, did that independent group make an informed business judgment after having done the dance, very similar to the traditional business judgment rule duty of care analysis, whether they make a judgment about whether or not the litigation should proceed. And if they determine that it should not, that it's in the best interest of the corporation to drop the suit, well then they once they've carried that burden, they also have to convince a court to conclude in its own independent business judgment whether or not that decision is correct. Now, what is the standard that a court will use in that context? Well, it's not perfectly clear, but it looks very much like the same standard a court might use in approving a settlement. And so really what is happening in these cases is empowering a group of designated directors to effectuate a settlement of whatever the subject matter is of the litigation, to come up with some resolution, whether it involves changing of corporate behavior, whether it involves the payment of money, whatever it involves, to then be presented to the court as the solution for the situation for their approval. And assuming that a committee does that with good legal advice after much study and deliberation, the chances that an independent business judgment of a court will differ from theirs is probably pretty small. So that's a quick overview of how shareholder litigation works in the corporate context.